Mkwedi Phuthi in the name of Jesus.
Amen. Now, yesterday, I had a conversation with Blessing, and she was focusing more on the different types of marital regime. But she was speaking more so not on the side of which marital regime to take. I don't think we sit here to advise anyone on any of those three more than we do expose you to what they mean.
Yes.
But she did speak on a bit of legalities. But she's an accountant. She's not a legal person. Yeah, she did point out that it would have been really nice to have a legal person in that conversation.
Yes.
And I kind of gave her my word that you would be in here today to address that. Now, our conversation today, guys, as you can hear, Mr. SK is not bringing it. I'm posing it to him. I am giving him something to have a discussion with us on.
Yeah.
He's very well aware what we're talking about. But I want us we've spoken about the different regimes of marriage, marriage contracts in South Africa, right? I want us to talk at length about them, but more so about the technicalities surrounding that. As you may know, recently we saw a battle in the courts. First, we saw a dragging divorce case between Ntlembali and DJ Black Coffee, Mr. Maphumulo, Kosinati Maphumulo.
Yes.
And we saw obviously a lot of uproar about the fact that at first, the first one was issues surrounding what we call alimony and child support.
Yes.
That was the first issue that was surrounding their divorce. Then we heard that she had won a case based on customary law, on the fact that was automatically in community of property. And we know how wealthy the man is, right?
Yes.
Then we heard that Black Coffee's lawyers went back to the court to challenge the decision, right? On the basis that they were both aware that they were not getting into a customary law contract. Now, with such arguments, Mr. SK, I ask myself as a person, Uguti, when a lawyer advises Lukho to get into a customary marriage with her spouse, in view of the knowledge that these people, because you must remember, these are public figures.
Yes.
We saw them celebrate their lobolas and whatnot. Are you, as a lawyer, number one, possibly hoping that which is wrong, but if divorce comes, the other party won't say, customary marriage came first? Because two, I want you to also address the issues around, I've gotten into this customary law, lobola is already paid already, and now we're approaching a lawyer. Why is it that the lawyer is not suggesting alternative routes, which is dissolving the customary marriage and then signing that contract? Because let's say, for argument's sake, both parties weren't aware before approaching the lawyers. So what I want you to address for us today is those issues. Could be alimony. I know we've got little time. Child support. Two, and these are all matters surrounding should divorce come. Two, what happens? We've just paid lobola. We've decided to get married. You approach a lawyer. Doesn't the lawyer know? What can they advise us? Three, you've gotten married in community of property, fully aware, right? But a lot happens along the way. Say, for instance, and I'm sorry to make an example with the men, but this is the most common scenario. Husband goes and builds a life somewhere else with somebody else. Or disappears into thin air. We don't know where he's gone into, but we know he's alive. Let's put that under record. And then he comes back one of these days and he's like, I'm divorcing you. I'm getting half of your estate. And generally, the public courts, like you always call them, will say, that's 50-50,
Yes.
But now we're hearing of technicalities along the lines, things such as forfeiture. What is forfeiture? When are people, or when are there grounds for forfeiture in community of property? Another thing she brought forth yesterday was out of community with accrual. let's talk about what accrual looks like, because we're building a life here together. We're both in this household. We're buying furniture. We're doing everything. How do you then determine at divorce level, Uguti, this is yours, this is mine, we've accrued this within? She spoke about a technicality of what, let's say for argument's sake, the wife is a housewife, and there's a formula that's now used to say, how do we divide these? I've said a lot, but you get the idea. I'd love you to speak to all those areas this afternoon.
All right. I think, Lukho,
it's a mouthful.
Yeah, I think firstly, Lukho, let's I love starting with definitions. Yeah, let's now define these types of marriages.
Yes.
One, we have marriage by lobola.
Okay.
And that's when the family of the husband approaches the family of the wife.
Okay.
To go and negotiate and pay a portion. Remember, currently there's a decided case, there's a precedent that says even if they've paid 1 rand.
I wanted to challenge that yesterday, because yesterday she made mention of celebrations and whatnot, and I said, I leave that to Mr. SK.
Yeah. you see now, celebration now, it's no longer an issue given this current court decision, you see.
Okay.
So then we have marriage in community of property. That is where now you share a joint estate. When I speak about an estate, I speak about movables and immovables.
All right.
I speak about finances.
Everything you own.
Everything you own. Because remember, when you enter, if we take it in a biblical concept, the Bible says the two shall become one.
Yes.
You see, so this is what happens with marriage in community of property. You become one in everything. In that all assets and liabilities are owned.
Okay.
Even before the debts that existed before marriage, you inherit them.
Sure. Okay.
You see, let's say I marry you, I come with 2 million debt that you were not aware of, and we marry in community of property. You become part and parcel of that particular debt. So that's when most of the people are not aware.
Yeah.
And this is now defined by what we say a joint estate.
Okay.
Then now let's look into the
sorry, before you move to that one, is it possible that two parties who got married, let's even say customarily, but that are married in community of property, can, at the phase of divorce, both have an agreement with their lawyers to say, to be fair, I want my ex-spouse to be free of my debt? Can that be a decision that both parties can make to say, look, whether accumulated before or after, I will settle my own debt. She will settle. Or do the courts force you to say, no, these debts will be separated, despite how you both feel?
You know, Lukho, when we speak of law, we cannot set aside the principle of Ubuntu.
Okay.
There's what we call ADR, mediation, Rule 41A.
Your favorite.
My favorite. You see, that one, I love it for some reason. I normally call it church court. Ask me why. There we negotiate, Lukho. A good person will say, you know what, my spouse, I will take care of these debts. Don't worry. Then we have what we call a settlement agreement.
Okay.
Hence, during divorce, we have what we call an opposed divorce
and an unopposed
divorce. An opposed one, it's where now people are arguing about children in terms of who's taking the primary care, who's taking the secondary care. People are now fighting over assets, properties. You see, then such a process becomes opposed. But an unopposed one, it's a situation whereby people reach a settlement, an agreement. They settle outside court. Then the lawyers will draft what we call a settlement agreement. Then such a settlement agreement will be taken to court to be made an order to say, this is how these people agree. Remember, you in consequences of incoming of property is that spouses share 50-50 in all assets and debts. But like I say, a good person will say, you know what, for the sake of my kids,
I don't want you to be inundated with these debts.
Let me leave my wife with the house for the sake of the children. You see? Then another one will say, no. We share everything. We sell the house and share 50-50.
Yeah.
We share the debts. If we've got 2 million debts, we pay 1 million, I pay 1 million. You see? Because of those are the consequences.
Okay.
In
this
marriage
type of marital regime.
Yes. So dissolution of marriage. Remember, there is 2 types of dissolution of marriage. It's either by divorce or by death.
Okay.
You see?
Yes.
Then in that way, the joint estate will still be divided equally in marriage in community of property.
Okay.
And the other thing, Lukho, that I want to bring to your attention and to the listeners is one. Marriage by lobola forms part and parcel of in community of property.
Yes.
So there are people who will rush to, because, hey, utando lwahlanyisa. When we get married, sometimes we get married out of excitement. And we later discover the consequences while we are now inside marriage. You see, because when we start, it's so nice, to get married. We become so excited that, you know what, we are getting married and so forth and so forth. But without considering the consequences that you may suffer if you rush to things. Let me show you something here. If you pay lobola before you sign the antenuptial contract, such a marriage automatically becomes in community of property.
Yeah.
So the first step, if you want to marry antenuptial, either with accrual or without accrual, I will explain what is with accrual, what is without accrual. The first thing that you need to do is to approach a notary. Is a specialized lawyer that specializes in special contracts, such as antenuptial contracts and so forth. You see, then such a lawyer will draft an antenuptial. Then you will inform such a lawyer of the assets which you do not want them to form part and parcel of the contract. Then they will be excluded. Then the contract will be registered. Then you proceed and pay lobola. So most of the people, you find that they sign a contract, they pay lobola, then after they come and say they want to sign the antenuptial, forgetting that the day divorce comes or dissolution of marriage comes, if the other party is to prove that lobola was paid, because when we marry it's nice, but when we part ways,
it's not as nice.
We become enemies, you see. Then the other one comes with evidence to say no, here lobola,
this person had approached my family already.
You see, something was paid. There were negotiations, there was a meeting of the minds.
I know you like that one, meeting of the minds.
Yes, because there wouldn't be contracts, Lukho, if there is no meeting of the minds. When we speak of law of contract, we'll always speak firstly about the meeting of the minds, because there must be the meeting of the minds. Then from there's agreement.
What do you think results in these type of disputable contracts? Could it be that the clients forfeit to mention to the lawyer that there's been lobola? Or could it be that the lawyers themselves, basically miss that detail? They don't ask whether or not the families have come together? Or 2, could it also be that the lawyer just does not want to look into that nitty-gritty because, hey, we could get away with it. Why? What do you think happens there? Because how does he allow me to sign a contract knowingly ukuthi there's been lobola somewhere?
Yeah, you see, Lukho, sometimes, like I say, lawyers will ask them questions because they're so eager to get married. Then they do not disclose certain information, and you see, there's vicarious consequences if you do not disclose certain information during consultation to your lawyer.
Okay.
Yeah, you spoke something about forfeiture. Who can forfeit or forfeit stuff during divorce or during dissolution of marriage? Now we'll look into Section 9 of the Divorce Act 70 of 1979.
Okay.
Which allows a court to order a spouse to lose their rights to financial benefits derived from marriage, preventing them unduly gaining from a marriage, essentially when they break down.
Okay.
But now let's look into key aspects of forfeiture in terms of South African law. The first one, remember, forfeiture is not automatic.
Exactly.
You see, factors that are to be considered are stated in Section 9, subsection 1 of the Divorce Act. The first one, Lukho, that we look into is the duration of the marriage.
All right.
Yeah, I know of a certain guy in Limpopo who goes around marrying this rich women.
Okay.
You see, then this guy will marry you in community of property. Sorry to say this, Lukho. You see, us mostly Christians, we feel because we are born again, we've accepted Jesus as the Lord and Savior. Then we because this happens mostly in churches.
Yeah.
You see, then this guy will marry these women who he sees that they have financial muscle, then stay in marriage maybe for a year or two, then divorce and claim 50% of their pension assets. Because he knows he's not working, he's just pastoring a church. So he knows that the ladies cannot claim anything from him.
Because he doesn't have those pensions or anything.
Yeah, he has nothing. You see, so he will now go and marry the other one. Hence, Section 9 speaks about the duration of the marriage, in that short marriages are more likely to result in forfeiture if one party tries to take assets they didn't help to build.
Okay.
You see, that's where now we are guided by Section 9. We look into the duration of the marriage, because
what do you think the courts would regard as a short period of time or a longer period of time, though? Or are there certain things or that it looks at to see whether or not it regards it as a short period of time? Let me make an example.
Yes.
A friend a couple of years was married. And they, I think they were married for about 3-4 years. But in that period, I think they had lived I think it was 3 years or 2 years. They had only lived for a period of about 8 months or so. And that was an argument that was brought forth to say, in the 2 years that they've been married, they've been living separate lives, because the other one has been in another province, the other one in another province. And within that time, they've only truly lived and been a proper family setting for about 8 months or so. So what would they consider as long enough of a period?
A short period of marriage, Lukho, obviously it will be anything less than a year.
Okay.
You see, yeah, or a year.
Okay.
Then, because again, remember, we will also look into the reasons for the breakdown. of that particular marriage.
Oh, so that matters as well.
Yes. Okay. There is a notion in law that says a bloody hand does not inherit.
Oh.
You see?
Okay.
Yeah. So this says there's couples that will go to even an extent of trying to kill their partners, so that they can now cap the issue of forfeiture, because
yes.
They know that when they are deceased, now they become they become the sole beneficiaries of that particular estate. So hence the law brought this notion that a bloody hand cannot inherit. If you came with wrong intentions, it's regarded as a bloody hand. It cannot inherit.
So is this notion also suggesting that in the event that, let's say, the other partner succeeds in killing the other one, they do stand a chance of not automatically gaining any of the other spouse's assets?
Yes.
Okay.
They cannot. They do not qualify to benefit from that particular estate. So they will basically forfeit everything.
Okay.
Because their intentions to enter into marriage were not so good.
True. Okay.
You see, like the man I just mentioned, you'll marry today and divorce, get 50% of the lady,
move to the next one,
then stay a bit and divorce, get 50%. You see, that's how he's making a living.
Sure.
So sometimes we shouldn't be led by sight. I think even the Bible encourages us that we should not move by sight, but we must be led by the Spirit. Hence, discernment is very important when you enter into, because when the two becomes one, we are one in spirit, we are one in everything.
Hence, development and growth.
And growth, we are one. Do you understand? Hence, where now there's behaviors of people behaving separately yet married, that causes dissolution of a marriage.
Oh, okay.
Where you find another partner taking their own decisions separately without involving the other spouse.
Could that also then contribute into that notion that bloody hands don't inherit?
Bloody hand does not inherit, because now
it's not necessarily literal.
It's not literal, but you see the intentions. Because remember, when you are in community of property, basically when you are in marriage, everything that you do, you must do it as one.
For the benefit of this marriage.
Yes, financially, it must be one thing. So you find the other party not disclosing what they are making, but expecting the other one to disclose how much they are making. That now renders the principle of oneness aside. It is now two people that are residing in one common home, but taking a different decision.
And possibly investing their finances elsewhere. I've seen a huge trend of, I think there was a sportsman that did it, and recently I saw a post, I think it was today, where somebody was saying, a lady was saying, I earn, I think, like 2 times more than the husband, but he doesn't even know I'm working because I'm a stay-at-home mom and I work digitally online, and my mom supposedly owns assets because she buys these properties and writes them under her mom. And so she's building a separate life from this husband, but the mom is the steward. And so the husband thinks the mom is doing well. Meanwhile, it's actually the wife's assets.
And you see, in such instances, Lukho, such marriages do not survive.
Because who are you building for? What are you building? That's the question. If you're here and you're building riches somewhere, what's the action plan? When will you ever enjoy them?
The purpose of marriage is to build inheritance for children's children. Do you understand? Then if such is not achieved, then it defeats the entire purpose of marriage.
You
see.
Sure.
So now let's go to out of community with accrual, Lukho.
Okay.
The definition here, parties married with a registered antenuptial contract, which normally we call an ANC, keeping their estate...
Not the party.
Keeping their estate separate during marriage, but sharing the growth of accrual of their assets upon dissolution.
In other words, what they've attained. That's what you mean by accrual.
What they have achieved from the date of marriage until the date of dissolution.
Okay.
That's what they only share. Then now the consequences here. Each spouse retains their own assets and is responsible for their own debts. It's now different from in community of property. In community of property, we share debts. So, but here, each party is responsible for their own debts.
This is without accrual, right?
This is without accrual.
Okay.
You see. No, this is with accrual.
With accrual,
yes, this is with accrual.
Okay.
Then the assets acquired during marriage are shared. It's with accrual. Whatever that accrued during the subsistence of the marriage, we share.
Is this only what we have accrued, or is this also speaking of the debts accrued during the marriage?
It speaks also the debts that we have accrued during marriage. Yes.
Okay. Is this a common regime that people go for then?
Normally, people will go for this one.
Okay.
Especially those that goes into
marriage with assets already.
Yeah, because you see, it will raise eyebrows, Lukho. I come and say, you know what? I marry you without accrual, without anything.
Yes. I mean, what are you careful of?
Yeah, because remember, without accrual simply says what is mine.
You live your life, I
live
mine.
What is yours, it's yours. The only thing that brought us together is marriage.
Exactly.
So it becomes a bit questionable.
Yeah, true.
You see, hence people.
But again, people are quite tact about that one as well, because they'll still say they'll tell you, no, I'm still in business, or I don't want my debts to affect you and stuff.
Yeah, you can be in business. You can still marry with accrual while you are in business. You see, hence there is separation of debts.
Okay.
You see, with accrual.
With accrual has separation of debts.
There's separation of debts.
So
yes.
it becomes a condition within that contract.
It becomes the condition within that contract that whatever you own your debts, I own my debts.
Okay.
You see, unlike within community, you are compelled to share the debts.
So one must not assume because it's out of community with accrual that means automatically I do accrue the debts. If it is stated otherwise, we can still exclude the debts. That's what you're saying?
Yes.
Okay. Though if it's not excluded, I will automatically assume the debts as well.
It must be stipulated in the contract.
It's not automatic.
This is a contract. You see?
Okay.
Yes.
So, hence you need a notary. Somebody who will be able to be detailed.
To detail the contract, to say, this is how parties agree. It's like a will.
Yes.
Yeah, writing a will to say, suppose I die, I want my estate to be divided. I want this one to be given to this, this to be given to this. You see? So that's basically that. Then now we go to marriage without accrual.
I know we're left with a few minutes, but I just want to ask this. Out of community with accrual, let's say the contract stipulates the separation of debts, for argument's sake, or anything for that matter. But during the marriage, I accumulate for the sake of the actual marriage together. But remember, I'm the one who took the debt based on our agreement.
Yes.
Does the same principle of Ubuntu that you spoke about apply, where we sit down with the lawyer and say, we understand that there's a separation of debt according to our contract. But because I accrued this debt, we are now, or the other party is now saying, no, to be considerate, we can share this particular debt because I understand that this is how you got into it. Does that still apply despite the fact that the contract excludes that debt?
Yeah, if the contract excludes, then it stands. We rely on what is in the contract.
Yes, but what I'm saying is, can you then, as the spouse, not there and say, based on the fact that, yes, I understand what the contract says, but I know that debt was to help the two of us. I choose to assist. So therefore, the ADR then says the other client agrees to assist ex-wife with that particular debt because he understands what the purpose is for. Can that be done in the settlement?
That can be done.
Okay, based on the other party's consideration.
Yes.
Okay.
We can't come here, look on the legal junction and not put in some little bit of case law.
Okay.
Yeah, let's check the recent trends of non-Tlantla Mtsali.
Okay.
In terms of non-accrual marriages.
Okay.
Where we have seen courts challenging the strict separation of assets, allowing redistribution based on fairness.
Oh.
You see?
Despite what the contract says, but let's speak of fairness.
Yeah.
Okay.
You see, because the law applies and works on principles of fairness.
This is interesting because basically what the law is saying is, we understand what your agreement was.
Yes.
But we are also going to analyze on whether this arrangement of your contract is still fair.
Yes. You see.
Okay.
So there's just a lot of case law that speaks to that. Because remember, there's also the issue of maintenance, Lukho.
Yep.
Where now we will look into the case of David Riley and Rachel Riley, where the court enforced maintenance and also imprisonment term for failure to pay maintenance.
Okay.
You see. And now this was later challenged to be unconstitutional under Section 12 of the Constitution unless failure is shown to be willful or malafide.
Or in other words, if the other one did not maintain because they just did not want to, then they may not necessarily be because they could not.
Yes.
They may not necessarily be arrested based on that verdict.
Yeah, because there was no willingness.
Yes.
Yeah.
However, if they are just not willing, then they should be arrested.
They should be arrested.
Okay, I hear you.
Or there is an order against them and they decide not to honor the order.
Okay.
Then that's where now the court can impose an imprisonment term.
Okay, I hear you.
You see?
But this does not say you will have to even when you have no means.
Remember when you go to maintenance, they will check your income and your expenditure. You will bring your bank statements as evidence to say this is how much I'm getting and this is how much I can afford. It's negotiations. And remember, we once spoke about maintenance here.
I'm actually thinking about that as you speak.
Yeah, and we also spoke about parties that takes people to maintenance court for purposes of punishment, not for purposes of the benefit of the children.
Okay.
You see, we would know we have parted ways. Ngzomkhomba, I'm taking him straight to the maintenance court. Yeah. Do you understand?
Yeah.
So that's a malafide approach because it's not done in good faith.
Yeah.
You get it. So such everything in law, Lukho, fairness must apply.
And I think the one lesson that we can take away today is that there's always a window in law.
Yes.
It's not black and white.
No.
It's not a case of ngoba the contract says.
Yeah.
You will.
Yeah.
Or even in the case of children, for instance, to say, I've heard people threaten people and say, you want to take him to court yet he's paying already. The court is just going to reduce that money. When in fact, the other party is rightly going because they believe the child needs more.
Exactly. And the other issue, Lukho, I think sometimes it's lack of Ubuntu.
Yeah.
Because if you are this now, I'm going to address it to fathers as a father, as we are about to knock off.
Yeah.
I mean, if you know that you've got children and now you want the court to inform you, to force you to take care of your children.
Yeah.
That's an irresponsible step, and that is lack of Ubuntu.
True.
And even love for the children that you have brought to earth.
Sure.
To understand?
No, definitely.
Yeah, but now remember, maintenance, the wheels of justice sharpens left and right. Also, mothers, we've got irresponsible and delinquent mothers that do not take care of their children.
Yeah.
To understand?
I think let's hold this one. Let's revisit it maybe next week, because I still have a lot in terms of questioning with this one.
Yeah.
You can just wrap it up, but I want us also to go back to without accrual. Look at what it means, and because it seems as though it's just simple.
Yeah. Without accrual, Lukho, it's straightforward. It's without accrual.
Yeah.
we share nothing.
But remember, there's the subject of fairness, like you said.
The subject of fairness, where you can write a will to say, no, I know we are married without accrual, but in my will, my wife or my spouse must benefit or inherit properties that I owned. All financial investments that I had should be inherited by my wife and by my children, or by my husband and my children. That is things that are done on basis of Ubuntu. It's not something that which it's supported by legislation, or legislation, or it's supported by law. It's something that comes from what we normally talk about here on the legal junction, natural justice.
You
see that your instincts, they speak to you, Uguti, I must take care of my kids. Your instincts tells you that I cannot assault or beat up my wife. Your instincts tells you that I cannot do certain things. Do you understand, Lukho?
Yeah.
So natural justice supersedes any legislation, because it now speaks with the inner man.
Yeah, the conscience.
The conscience. It speaks with the man within.
I love what you just mentioned, because it kind of reminds us to just think, Uguti, we must never think that the law excludes issues of conscience. In actual fact, when it is formulated, conscience and like you'd always say, what's this word? But basically it's values, morality. All these are taken into consideration when formulating the laws. So they will be revisited when arguments are made.
Yes. You see, so the law is very fair, Lukho. I think let me close it with this Latin word.
Okay.
Sed lex, which simply says the law is hard, but the law is the law.
Okay.
You see, so sometimes people, when the law deals with them, they may think that the law is punitive. You see, only to find that the law is not really punitive, but the law is the law.
Yep.
Hence, ignorance of the law is not an excuse.
Okay.
You see, so I think that is it, Lukho. We have educated our listeners as we normally do every Thursdays. They've learned a lot when it comes to issues of marriages. Don't marry out of excitement. Assess and know the consequences. I know. As Christians, we always
question the other regimes.
And to say we are Christians, we don't even think that dissolution might come. To understand? Hence, when dissolution comes, it hits very hard, because we always agree in the notion of till death do us part. But the law is real. To say,
I think. One thing we need not forget is that nobody marries to divorce.
Nobody marries to divorce.
I think that's the grace we need to offer the family today, to say we're discussing these things not because we're saying it's going to happen, but because we've seen them happen.
Possibility, you see, possibility, because even if we can be ignorant, Lukho, these are issues that people are suffering on day-to-day basis. To understand, we cannot put a blind eye on it. It's something that which people on day-to-day basis. I saw the statistics that our divorce courts entertains in a day more than 50 to 60 divorce cases
in a day, guys.
In a day.
And you do know Christians are leading in terms of stats, right?
Yeah. Okay. Christians are also included. We cannot set them aside.
Okay.
You see, pastors, we cannot set them aside. So we just here to raise an awareness to say, one, it is not good, yes, to divorce, but it may, if it happens to comes or to come, then you need to know your legal standing. What are your rights? What are your entitlements? That is the reason why we are doing the legal junction every Thursday here on Radio Pulpit.
Now we have to close.
Let's close it up. From myself, the only lawyer of the radio, we're meeting again, same time, same place on Radio Pulpit, 6:57 a.m. God bless you.
Please give your contact details, your email address that people can contact you on. I'll tell you later on why I'm asking for that.
Okay.
Email address?
I think let me start by the website. They can go to our website, www.seakamela.legal.co.za, www.seakamela.legal.co.za. Our contacts are there. Our WhatsApp number is 078-306-0456, 078-306-0456. And as in Lukho, I think let's also raise this one. When they call this listeners, I don't have a problem that they contact us, but please guys, don't call in the evening. I also need to rest. I also need to rest. I'm human too.
From your heart and handing everything over to you, we've got to love and leave you. Thank you so much for tuning in. As you might have seen, we're probably going to follow more of this. God bless.